Good evening to everyone present here. I am Avneet Kaur, member of Sambhav Initiative and moderator for today's session. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Justice S.J. Mukhopadhyay sir, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Court Practice, Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about judicial insights of family law. It is my honor to introduce our distinguished jurist and an eminent figure in the Indian judiciary, Honorable Justice S.J. Mukhopadhyay, sir, former Judge Supreme Court of India and former Chairperson National Company Law Appellate Tribunal. Sir pursued his BSc from the Magad University in 1971 and obtained his LLB from the University of Patna in 1979. Sir was enrolled as an advocate the same year and began his legal practice at Patna and Ranchi benches of the Patna High Court, handling matters related to constitutional service, civil and criminal law. Sir was designated as senior advocate in 1993. Justice Sir was elevated as a permanent judge of the Patna High Court on 8th November 1994. Sir later became one of the founding judges of the Jharkhand High Court upon its formation in 2000, where he also served as acting Chief Justice. In August 2006, Sir was transferred to the Madras High Court as its first judge and also discharged duties as acting Chief Justice. From December 2009 to September 2011, Sir served as the Chief Justice of Gujarat High Court. On 13 September 2011, Sir was elevated to the Supreme Court of India, where Sir served with distinction until his retirement. During his tenure, Sir was part of several landmark judgments, including the interpretation of Article 243D and the reservation limits under the Bihar Panchayat Raj Act. The high profile fodder scam and bitumen scam cases at the Patna High Court, the Supreme Court verdict upholding the constitutional validity of Section 377 IPC, and many others. Post retirement, Sir was appointed as the first chairperson of the National Company Law Appellate Tribunal on 1st June 2016. In this role, Sir has played a pivotal part in shaping the interpretation of the Insolvency and Bankruptcy Code 2016, delivering several important judgments in an area of law that had no prior precedent. We are deeply honored to have you with us today, sir. Over to you, sir.
Good evening to all of you. I cannot take the particular name except Dr. Kalpesh Gupta and Avneet Kaur were before me. But I can find that who are actually present. Number of persons present, I don't know. I'm glad that the organization thought it proper that I am the person who can talk about the family law. Now, a subject which is a vast subject, which can be looked from the 360-degree angle. And in the modern days, where the family definition is going on still under consideration in different aspects. Traditionally, the family law viewed family as a unit consisting of husband, wife, their children, and amongst the Hindus people, there are grandparents also are the part of the family. The definition of family is not there except in code of CPC, that is the CPC. That means which defines family broadly a man and his wife living together. The children together form either spouse. Any children legally adopted or by or both. Any other relatives or dependents living together or maintained by such man or woman. So that includes the grandparents. That includes maybe in certain part of India, the in-laws, Now, in India, the family can be defined in a different way and from the look into from different aspect. So whatever is in North India thought process may be different in the South India and different in the Northeast. For example, or Kashmir. For example, the family in India, particularly amongst the Hindus, there is no provision of marriage in the seven sapandas. But in South India, including the Tamil Nadu, the best marriage is that of the niece, which we call Bhagni, and the mama, that is the first preference. So there, after the marriage, they generally the sister who becomes the mother-in-law, they come to the house of the son-in-law. That's who is the brother. But in South India, in North India, there's a different way of looking to this. It's not a blood relationship. Is not there for the purpose of husband and wife. The best relationship between the husband and wife are not the blood relationship. Whereas amongst the Islam or like those who are followers of the Islam, the blood relationship is also permissible. So India, the family law cannot be put into four corners of, but it is to look from the 360 degree of the angle. So family law, when we talk of, then we are also looking into the unmarried people, like the sisters who are in the family, maybe, the aunties in the family. So there are different places. It is, I cannot say that nowadays, one even smaller unit of a husband and wife. So first of all, the case wise, every case is to see that how the family constitute in that case. Now, traditionally, what has happened when what has been defined is now explained in a different way. Supreme Court, in recent judgment, has explained the definition of the family beyond traditional model. It recognizes familial relationship includes domestic, unmarried partnership, queer relationship, single parent households, blended families from remarriage or adoption, guardians or caretakers acting as family members, thus reflecting modern social relations and protecting various family structures. And the law is developing and is will develop. You know, since we traditionally there are different ways of the acts. There are secular law, there are Hindu laws, there are Christian law, there are Muslim law, Parsi law. So different fields which are there. There are different acts. Some of the acts were enacted in pre-independence time, like Arya Marriage Validation Act 1937. You'll be finding otherwise Hindu Marriage Act 1955, Hindu Adoption of Maintenance Act 1956, Anand Marriage Act 1909. So many of the marriage system are unknown nowadays. Anand marriage, unknown. And many of the Arya Marriage Validation Act. So Arya Samaj, they marry in a different way. Then Succession Act. Actually, what is the family law? Family law can be carved out in a civil side and in the criminal jurisprudence. Civil side, apart from that, there are different laws like the secular law. You must have been said in the last few days deliberation, like the Special Marriage Act, Foreign Marriage Act 1969, Indian Succession Act. So The marriage with family starts with a marriage generally or a couple, male and female, followed by a child, and then it increases. The moment you in English, if I say, after the marriage, you will find in-laws. I'm just simply giving brother-in-law, mother-in-law, sister-in-law. Brother is there who is in the family. But brother-in-law is according to the law, he has become the brother. Or mother-in-law, to mother, but in accordance with the law. So how the family constitute it varies from different state to different state. For example, in the tribal area, like say northeast, you will find that the after the marriage, the husband goes to the wife's family, particularly in Meghalaya, all three hilly region. So how the family constitute, but there are the law which are guided by either Special Marriage Act or Hindu law or Christian laws. And the moment the laws have been enacted, or Muslim law or Parsi law. So the moment the law was enacted, slowly it was found there are problems. The problems was that there is a separation. Husband wife do not want to stay together. Then came the divorce. So how the divorce will go on? So it is in all law, there is a provision of divorce. Then child's right, and right of the parents to have the child over the child. Then death will be there, or separation will be there. Then the right of the Succession Act, who succeeds. So it also varies from time to time, from marriage to marriage, different types of marriage, and different types of religions and acts. So Hindu Succession Act is one, but there is nothing like Indian Christian Succession Act or Succession Act I find in the amongst the Muslims. So they have their own law, which is the Islamic way of following the law as per the Muhammadan law, not a special act enacted. But Indian Succession Act 1925 is the secular law, can be applied in different, it has nothing to do with a particular religion. So there are laws which have been enacted from time to time. These are the civil act. Now, civil act is one thing, and another is criminal act. Now, criminal act is also found the moment the development of law, if you see in the family, then you will find that there are acts which have been enacted later on, which includes Domestic Violence Act. Domestic Violence Act, you know, the moment that the Domestic Violence Act comes with a criminal jurisprudence, but with some essence of civil nature. What are the benefit one can get even under the Domestic Violence Act? Domestic Violence Acts also, that is for the purpose of protection of the purpose of women. There is no law. This act is all act mainly relates to the woman, not the male. So that act came in 2005. To that extent, only 20 years back, not 1990s, not the pre-British period. So the thing that a domestic violence act came, that is also amongst a family in a sense, that those who are residing under the same roof. It may include any woman, but the respondent will have to be a man. If the man will be a respondent, then the domestic violence can be applied in a family. No domestic violence, unlike the mother-in-law and the daughter-in-law, cannot be taken care of that. There is something which are in the Indian system, the law has not interfered with. I'm talking of the family law. So these are the part of the family law. Time to time, it has been seen and it has been enacted. Then other law is protection of, you know, as per that, also protection of women from domestic violence, the rules has been framed. You'll be finding the compensation are there. Cruelty is a different nature of cruelty is stated. It is not only one. That also economic, you know, economic offense. So that cannot be claimed by a husband. That can be claimed by a wife with regard to abuse or abusive language. There are, you know, provisions under the Domestic Violence Act. So, in one side, the civil in nature is marriage, marriage registrations, then the right of a child, custody of a child, then comes the succession. So they are one part. The other side is the criminal part of the family law. So if you see the criminal, so 2005, the criminal that Domestic Violence Act came into force. If you look into the relief and the offense, it takes into consideration different types of offense which are not there under the IPC, economic offense or abuse. So they are taken care between the parties, male and those who are unrelated but live like a family under the same rule. So family law, when we talk of a family who are also living under the same roof. And recently, it was found that old age people, there are old age people like the grandfather, grandmother, or those who are senior citizens and having no earning capacity or no capacity to feed them are being also not treated equally by the family members, even own relations. So in 2007, the Act came Maintenance and Welfare of Parents and Senior Citizenship Act. So parents' right and senior citizens' right that was also accepted in a family in 2007. So slowly the evolving the family size. That means you can't throw them out. So they have also a right, and it is not the right. The law permits there the maintenance of the old people. Children include son, daughter, grandson, granddaughter, but does not include a minor. So the moment they say the old people, parents, or the senior citizens, they include not only the son, also the daughter, grandson, granddaughters, and it will be applicable. Maintenance includes provision of the food, clothing, residence, medical attendance. So these are the things. slowly, when the society is changing and the behavior of the society is changing, that means the unit is becoming singular in nature, that husband and wife. Maybe in relations, that is a nowadays you will be finding live-in relationship. So live-in relationship also may not allow the parents to interfere with the matter. They may be thrown out. So family, that system is now changing, and the moment changing and evolving, and all the actions which are act of the human being, which are being increasing, which are not the act in accordance with our old system. The law is enacted. And there, a senior citizen, he can file, or a parent can file, or any person. If he is incapable, then other person, organization, or authorities authorized by him, they can file. They can move before a tribunal constituted for that purpose. So, family law, when we are looking into, so we'll have to look into different provinces of the family law and how the society is changing, how it is evolving, and the law is not same law, is not maybe applicable in a different way. There is no way, the law applicable for a person who is a Hindu having the Dabhag right, the Succession Act will be different. Mitakshara will be different. But amongst the Muslim, the moment will be there. What will be the succession right? Except the secular law of succession. So it is not a particular thing, a particular court of law. Somewhere you will be finding it as the magistrate's power. Majority of the power has been given to the family court, which was earlier vested with the civil court. So civil side is the family court. And the criminal jurisprudence, the moment comes the magisterial power and the, say, juvenile, this domestic violence act. But the power to grant relief is like a civil dispute without a divorce. The wife can ask for maintenance allowed. So it is not that the maintenance, etc., are one way under the particular act. So when the lawyers or the student or who will be practicing in the matter, you will have to first look into the nature of the case. The general, I have said that there are different types of law. There are different types of law evolving and will evolve in future. POSCO. Now, when the POSCO Act has come, 2012. Now, there, the act is a criminal act against the child. But the moment the child is there, they're part of a family. So you can't say POSCO is not part of the family law. POSCO is also attracted to a family law because they are part of a child is a part of the family. And these laws are secular in nature. Domestic Violence Act or the POSCO, which are criminal offense, which are the attracts the criminal jurisprudence. There you'll find religion has no role to play in that matter. The law is equal for them. For the purpose of marriage, for the purpose of divorce, the law may be different. But for the purpose of criminal jurisprudence, the law is same. It's the secular in nature. These laws are also secular in nature. Apart from the general secular law, like the Indian Succession Act or Marriage Act, these are also criminal jurisprudence law, law relating to criminal jurisprudence, they are secular in nature. Therefore, the purpose of lawyer or a student, when they will be going before a court, they will have to decide that before which court I am liable to go. What are the act of, the when the person moves before a court of law, when there is a dispute, in a family, then the aggrieved persons first goes to a lawyer generally. And because they give the opinion, they give the law, and they have the right to file, or no party person in concern has the right to move before a court of law. But lawyers, students who are before me, I do not know. When you will be going, you will have to look into that, what are the problem. And then, who are you? Are you a male or a female? Or a respondent or a petitioner? So, the persons will be equally distanced and placed in opposite sides. So, one lawyer will be appearing on behalf of one party, and there will be also corresponding another lawyer who will be from the another party. So, same law will be argued in a two different way. The fact which will be taken into consideration, the fact may be admitted fact, maybe the fact is to be established by evidence, maybe the fact is recorded by police in a criminal case, maybe the state is the party, but the lawyer will be always there either from this side or that side. So, two ways of looking into the matter. 180-degree from one side, which is the dark is nature, that side, you will have to focus. And another side, maybe 180-degree, which is the bright side. But, when the time changes, like the world, the bright side, if you look into you may find the darkness in that. And in the darkness also, if you throw your light, then you may find out some points over there. So there is no fixed system of drafting. Drafting will be become, one thing the lawyer must keep it in mind, or the students must keep in mind, that party is the master of the fact. Lawyer are merely, they know the law, but they are master of the facts. I'm a person from Bihar, basically from Bihar. So in our state, there is what they say, kahawat, their proverbs, sahar sikhaya katwal. That means those who are complaining coming between the SHO, they will say, what is the problem? Then the SHO can record only that statement. So fact is, lawyers, when they are coming before lawyer, that means a party knows that I have a problem. And the party knows the problem. Lawyers should hear all the facts. Because you don't know that which fact will be applicable and is the best fact in your favor. And then you can find out whether law is in your favor or fact is in your favor. So every case, there's a point of law, but there may be a point of fact in your favor. So what is in your favor? So there is no typical, I will not be saying that the practice or drafting will be equal. Practice and drafting would be different for different cases. From two different sides, the drafting would be different. Those who will be filing a case as a plaintiff or as a petitioner or as a complainant, their drafting will be one. Those who are other side, particularly male member, because under the law, most of the law you'll find there is no security for the male. There's only the security for the woman, even in the matter of divorce, even in the matter of except for succession. Their right to be succeed, there may be equal right in the civil side. But in the criminal side, its offense is always committed, perpetrated to have been committed by a male. So, for domestic violence act, for example, you can't file a case till a respondent is a male. A female can be added only if a male is the respondent. That means complainant will be always a woman or female. Even in the matter of POSCO, the offense will be always committed by a male. He, not she, not a person. So there, where you are situated, whose party you are appearing, you will have to look into the facts. You will have to jot down the facts and record the facts in the manner that which is a clarity of thought process for a court of law, for a tribunal, for a judge, for a third party to understand. So a layman can read it and can understand the facts. So facts are to be jotted down in a manner which are real fact and certain facts which may be, when it is a respondent, then respondent or defendant, then in that case, he will be looking to the allegation, then he will be drafting. But when the plaintiff or somebody, then he will have to draft or make the case in the manner beneficial to the client. So client may be a male, may be a female for the purpose of divorce. Divorce, merely you'll have to first look into the fact, the law, that a case is made out by the parties or not. There may be a dispute between the husband and wife. The dispute can be resolved by way of conciliation. It can be resolved by way of mediation. So when everywhere it is not a case which is to be go before a court of law, there are other forums which is to be availed where there is no specific violation of a provision, and particularly in the matter of divorce. The previous thought process of the court was that they should live together. Now the thought process is that if the young people have the divorce, then let them part together and they let them go separately so that they can have a separate good life. If the problem is such in the young age of a divorce, 28, 29, the girl age is also similar, 30, 31, no child, and the divorce is coming, and a person is coming with the 55 years old and or 60 years old is coming for divorce. So two things are different. So in all the cases, it is first better to go for a mediation or conciliation. Can they sort out their problem? And what mediators do? Mediators act like a catalytic agent. They don't put their opinion on the parties. They place like a catalytic agent to find out that what are the problem, which will be problem which may be arise and how to sort out. They can suggest, but they would have to suggest in a manner which is palatable and acceptable to both the parties. So first forum for the purpose of a separation, then is the mediation. Because in all cases, please do not make out a case like a lawyer just for the purpose of divorce. Don't place witnesses only for the purpose of making out a case of divorce. That means lawyers should desist from telling a lie before the court. You know, that is the ethics of the profession. It is not the earning, not the client will go out of your hand. One thing you will remember, if you can sort out the problem, if you can dispose of a case an early date, if you do not charge in every day hearing, the more party will come before you. Otherwise, in a case will be tagging the matter and may draw the fee from one party, but you will not be getting the number of parties. So it is not in how many fees you are earning, how your reputation you are earning in the young age. And when the reputation you are earning, you have to ensure that a reputation means the people will say that he is the person who is expediting the matter. Now, judiciary is being blamed for a delay. And the delay, I will not blame any person that whether the judges for them or system for them or the lawyers for them or the young generation for them or the old generation for them, blame game is not the answer. The system is the party must get relief. Both the parties. Dismissal of a case, separation or reprieve is a, what is justice does not mean that both the parties should get everything. But in a matter of mediation, is a practically win-win situation for both. And a win-win situation for both, then both the parties think that my lawyer is good. My person, who is the authority, he is the person who has shown me the door for early relief. So what is there? If you can ensure that early relief to a person, please, your behavior should be first. So drafting or court procedure comes later. First is your thought process. First, a lawyer, a person who is handling the matter, should handle the matter to ensure immediate justice or quick justice delivery system. So quick justice delivery system is not necessary that you will have to draft a petition. Even for compromise, you can draft an agreement. So drafting does not mean that the court before whom you have to do. Pleading does not mean that you have to plead before a court of law. So any forum, for example, the parents, they will have to move before a tribunal. And tribunal will be SDO, who is an officer of the state. So there, if the officer of the state can decide the matter, the mediator can also decide the matter. But last stage is a court of law. And court of law also, if you go before a court of law, not to teach a lesson to the other person. The object should not be of a lawyer to teach a lesson to the other side. The object should be, let me get the lesson out of this case. So deriving the satisfaction of the case, deriving the satisfaction of the law, understanding the law, deriving the satisfaction of argument should be the satisfaction, not the satisfaction of the teaching somebody in a sense that I'll be teach you. Teach yourself first. So teach yourself to get the satisfaction in your life. And you will be getting the success if you are satisfied with your pleading, your way of communicating the thing between the two. Your whatever you communicate, the person should understand the other side in the manner you want to communicate. Not the law is that. One thing I was heard when I was a young lawyer, one judge was there in Patna High Court. He said one thing in Hindi. आदमी के लिए कानून है या कानून के लिए आदमी है? That haunted in my mind all the time. Law is meant for people, not that people are meant for law. People are supposed to follow the law, but not that law has been made because of problem. So do not create more problem to a person who is in problem and coming before you. You learn out of that. The law you will be learning from that. Your learning of the law will be first thing. Your experience of the law of argument will be second thing. Then the earning out of that for the purpose of feeding yourself. So earning cannot be the first, subject matter. You cannot put a cart before the horse because the money will be before the cart. So cart will follow. If you run, then the cart in the backside will follow you. People will chase you and put the money. The clientele will chase you, not that you chase the clients. So don't chase the money. Money is required. How to earn the money is another subject. That a lawyer, I can tell you that how to earn the money. There's another subject. The lawyer is to, you know, they will have to earn. They'll have to survive. But I think my time is over. Mr. Gupta,
Yes, 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 sure.
my time is over.
So we'll take up two, three questions if you permit, sir.
Yes.
Yes, sir.
Thank you,
But
sir. Now we open the floor for question and answers. Whosoever have any questions can raise your hand or can write your question in the chat box. So there are a few questions in the chat box. If the definition of violence is broadened to include economic and mental violence, then what are your views on making this law as gender neutral?
You're talking of which law of violence?
So it's definition of violence if it is broadened to include economic and mental violence.
In which act?
So the
Domestic
questions
Violence
are
Act?
uh,
Domestic Violence Act?
so here
Economic
it is
offense?
written like this. Arun sir, you can unmute yourself and
You see,
ask your
I'm
question.
telling you, the economic offense is in the Domestic Violence Act and it's for women. Domestic Violence Act is for protecting the rights of the woman, not the male, against a respondent. So respondent will have to be a male. Economic violence will be that if a female is not earning, the
yes, sir.
husband is not looking into. So these are the
Yes,
things. It's not gender neutral.
yes, Anand Kumar,
Gender
you are raised. Sorry for interruption, sir. Sorry.
Good evening, sir. Thank you very much for the insightful session. My question is the DV Act gender neutral? And if it is not, is it not in the
which
right time to make it
which
gender
which
neutral
which,
because of the changing gender rights landscape?
which act?
DV Act,
BB Act means.
Protection of Women from Domestic Violence Act.
So protection of women, not the male.
But
I
it should
said
be
the
made
law is.
gender. It should be now gender neutral, sir, given the landscape which is changing. There are many cases where
Somebody asked me, one of the research associate with me asked me that where there is no law for the male. I said there is a law for the male child, that there is no law for the female, male adult. So I said, let there be a woman MP in this country will be more than 50%, then there will be a gender neutral law at that time. Nowadays, all cases, the respondent, and protection of women, you are saying, you are making it PW. I do not understand the shortage. So protection of women do not protect a man. So it is not gender free. The only thing is POSCO Act, where the child, when they take, where the male child are also protected, like the woman child. Even those who are neither of the sex, then they are also protected. So child is a different forum. Otherwise, no law to protect the male, except the criminal law, which are the activities in a different nature which has nothing to do with the family law. Family law do not protect, because still in India, the male-dominated society is accepted. I'm saying that in the Meghalaya, it is a female-dominated. After the marriage, the title of the husband changes. The title of the daughters and the sons are that of the mother. So there are places. So it may be different places, the law may be different, that is, they are following the tribal law of their own. But Indian general law, including the secular law, do not protect the men. Changing society may do it the moment you allow the woman to be more than 50% in the MP, then may protect you. Male will be dominating the parliament, will never protect the male. Am I clear?
Good evening, sir. Then the second follow-on is, then in case a male is suffering in a relation, what is the recourse except that going for a divorce?
You know, if the male is suffering, the suffering will be physical or mental. I'm asking you.
It can be both, sir. Even a mental
No, no,
stress can be there.
just a case. If the physical is there, then you can go for the physically there. Then when I was the Chief Justice of Gujarat High Court, there was a case filed, पत्नी पीड़ित, हस्बैंड के बारे में, पत्नी पीड़ित. तो पत्नी पीड़ित नहीं होते हैं ना हमारे देश में. देयर इज नथिंग लाइक एसोसिएशन विद पत्नी पीड़ित. The mental, there is a mental torture. But if you behave well, then if you behave well with a female, then there will be no torture. So the thing is that the male will have to go for a conciliation. They will have to take the wife to a conciliator or a mediator or a psychiatrist who can be also a mediator. Mediator does not mean, because if the wife's behavior is such that male is suffering, then she should be taken for mediation to a perfect person, either to a doctor or a psychiatrist or a mediator. So that is the first of all, that is the only treatment which can be made. Divorce is the last one, because divorce do not say mental torture, do not allow, physical torture. They do not allow economic torture. So those tortures are not the ground for the purpose of divorce.
Thank you, sir.
Thank you so much, sir. And on behalf of organizing committee, I extend a sincere gratitude to you, sir, for such an enriching session today. We are truly
Thank you.
thankful to you, sir, not only for accepting our invitation, but also for taking the time to guide and inspire all the participants. Thank you so much, sir.
Thank you. Thank you all.
Thank you, sir. Thank you.